Welcome back to the deep dive. Today, we're taking a really close look at a fascinating area of law. It touches on everything from, big business secrets right through to personal privacy. It's breach of confidence.
That's right.
And this deep dive is based on material made available for educational purposes by the University of London. We should also mention this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
hmm
And look, to all of you preparing for your exams right now, we really wish you the very best of luck.
Yeah,
Keep studying. You've got this.
absolutely. And breach of confidence, it's a topic that, well, it might seem a bit historical, maybe, being judge-made law developed over centuries, but honestly, it is incredibly relevant today.
Oh, definitely.
Just think about protecting sensitive business strategies in the digital age, or, safeguarding personal information online. So our mission today is really to unpack how this legal action works. Understand the specifics of circumstances when it pops up. Look at the defenses available if someone is accused, and explore the remedies the court can actually grant if a breach happens.
Right.
We'll also try and highlight some key areas where the law has evolved quite dramatically in recent years, actually, and maybe where there are still some questions for the courts to figure out.
So if you've ever wondered how ideas or secrets, the kind that don't neatly fit into, say, patents or copyright, how they get legally protected, or maybe how privacy is protected from unwanted exposure by the media or others, well, this deep dive is specifically for you.
Mm-hmm.
We're going to go through the essential building blocks, the core tests, and the absolutely key cases you need to understand this topic thoroughly. Hopefully, it'll help you feel ready to tackle it in your exams. Let's jump in.
Let's do it.
So, right at the top then, why do we even need something like breach of confidence? Don't we already have things like patents or copyright to protect valuable information?
Yeah, that's an excellent place to start, and it gets right to the heart of why breach of confidence is, well, unique. You're absolutely right. Other intellectual property rights, like patents for inventions, copyright for creative works, registered designs for how products look, they're all crucial.
Sure.
But they typically protect specific forms of information. A patent protects an invention described in a very specific way. Copyright protects the expression of an idea, the words, the music, the image in a tangible form.
Okay.
Designs protect the appearance. And they often need some kind of formality or registration, maybe, and they
Yeah.
protect against very specific types of infringement.
Right, so they're quite defined.
Exactly.
Yeah.
The action for breach of confidence, though, it's different. Its real power lies in the fact that it protects ideas and information as such.
As such, what do you mean?
It means it protects the content of the information, the secret itself, regardless of whether it's written down, spoken, or just an idea someone had. It's not tied to a specific tangible form like those other IP rights are. That's the fundamental difference. Let's repeat that. Breach of confidence protects ideas and information themselves, unlike other IP rights, which often require tangible form.
Okay, so it's about the information itself, the core idea, not necessarily the physical document or drawing. That sounds incredibly broad.
It is broad, yes. But there's an important nuance here in UK law. Traditionally, UK law doesn't actually recognize a property right in information itself. You can't own information like you own, say, your laptop.
Okay.
This was famously stated by the House of Lords way back in Boardman v. Phipps. But what breach of confidence does is impose an obligation on a person who receives confidential information.
Obligation.
Yes, an obligation preventing them from misusing it. So while you don't technically own the information, you have a right that others won't misuse it if they receive it in circumstances that create that obligation.
Ah, I see. It's about the duty not to misuse it.
Precisely. Now, it's worth mentioning, especially for commercial secrets, this area has also seen some, influence from EU law. There's the Trade Secrets Directive,
Right.
EU 216943.
Right.
And the UK implemented that via the Trade Secrets Enforcement, etc., Regulations 2018. Now, when the UK did that, the government's view was that our existing judge-made law on breach of confidence already largely covered what the directive required for protecting trade secrets.
So we were already doing it.
In many ways, yes, and often UK common law provides more favorable protection than the minimum standards set out in the directive. The 2018 regulations mostly added some specific procedural rules, things about remedies, interim measures, rules about returning documents, just to ensure full technical compliance.
Okay, so the regulations kind of tidied things up. It didn't replace the old law.
Exactly. The underlying judge-made law of breach of confidence for trade secrets, that's still the foundation.
Right.
And where it offers stronger protection, that protection remains available. This was actually confirmed in a case called Shenzhen Senior Technology Material Co Ltd v. Selgard LLC. Lord Justice Arnold in the Court of Appeal explicitly said that if UK law provides higher protection for a trade secret than the directive requires, well, that higher, more favorable protection is still fully available even after the 2018 regulations. So the old common law is very much alive and kicking.
That's really interesting. So breach of confidence is like this flexible safety net protecting information that might slip through the cracks of other IP rights. And for trade secrets, it's potentially even stronger than the EU standard. Where did this powerful, flexible idea actually come from historically?
Yeah, flexible is a good word for it. Its origins are firmly in judge-made law developed over hundreds of years by the courts, particularly the old courts of equity.
Equity, meaning fairness.
Exactly. Equity was all about fairness, good conscience, preventing unconscionable behavior. And that's absolutely key to understanding this action. Some early cases sort of laid the groundwork. You had Prince Albert v. Strange back in 1849.
Prince Albert, Queen Victoria's husband.
The very same. He'd made some private drawings, etchings, showed them to a printer under, an understanding of confidence. The printer made unauthorized copies and planned an exhibition. The court stopped him, granted an injunction, recognizing that breach of confidence.
Wow.
Another classic is Morrison v. Moat from 1851. That involved a secret recipe for a medicine passed down in a family business, and then someone misused it.
Right.
In those early days, the courts sometimes, they struggled a bit to pin down the exact legal basis. Sometimes they tried to frame it in contract law, especially if there was an agreement. Or even, as in Prince Albert, they talked a bit about property rights, ownership of the copies.
But you said earlier the modern view isn't contract or property.
That's right. The modern law is absolutely clear. The basis is the equitable concept of good faith or conscience. It's about stopping someone acting unconscionably, unfairly, by misusing information they got in confidence. This was really cemented in a case called Saltman Engineering Co. Ltd v. Campbell Engineering Co. Ltd. back in the 1940s. The Court of Appeal made it crystal clear the obligation arises from the circumstances the information is received in, not necessarily from a contract, although a contract can certainly create or reinforce the duty. Let's repeat that. The basis of breach of confidence is the equitable concept of good faith or conscience.
Good faith and conscience.
Yes. And many important judges have hammered this home. Lord Denning, in Fraser v. Evans, said it was based not so much on property or on contract as on a duty to be of good faith.
Right.
Lord Keith, in the really famous AGV Guardian newspapers, note 2, that's the spycatcher case, he stated the obligation can exist independently of any contract on the basis of an independent, equitable principle of confidence.
So even without a contract?
Even without one. And just recently, the UK Supreme Court confirmed this basis on conscience again in Vestergaard Franson ASV Bestnet Europe Ltd. So, while contracts are common, the core equitable duty exists anyway, rooted in fairness.
That shift from trying to fit it into contract or property to basing it firmly on conscience, that seems really important. It must make the whole thing much more adaptable, right?
Absolutely. Massively so. It means the courts can look at the specific situation, the context, and decide if it would be unfair, unconscionable for someone to use or spill the beans. It gives them flexibility, which is vital given the sheer variety of ways confidential information gets shared.
Fascinating stuff. Okay, now we understand the foundations, the history. Let's look at the different kinds of information this action can actually protect. You mentioned commercial, personal, and government info earlier.
Yeah.
Can we break those down?
Sure. As we said, it's very broad.
Okay.
First, maybe the most traditional area in business is commercial information. This is absolutely vital for protecting things like trade secrets and valuable know-how.
Like what specifically?
Well, it could be a detailed idea for a new gadget that isn't patented yet, or the concept and format for a new TV game show, a specific manufacturing process, a technique that gives a company its edge, pricing strategies, maybe, even a carefully compiled list of customers or suppliers.
Right, valuable stuff.
Exactly. Cases like Seeger v. Copydex, No One, that was about a carpet grip idea, and Fraser v. Thames Television, about a TV series concept. They're classic examples of protecting commercial ideas that weren't, protectable by patent or copyright at that point, remember. Commercial information like trade secrets, ideas, processes, and customer lists are protected.
Got it. What else?
Second, personal information. This is about sensitive details about someone's private life, their health, relationships, financial situation, anything they'd reasonably consider private and expect to stay that way. And this, as we hinted, is where there's been huge development recently, linking into privacy law.
Okay, and the third?
Third is government information. This covers sensitive stuff held by the state national security secrets, ongoing police investigations, confidential policy discussions. Here, the courts have a tricky balancing act between the government's need for secrecy and, public interest factors like transparency or accountability.
So the same basic principle of fairness applies across the board, but the context really matters for things like justification. You mentioned the commercial focus for today, but honestly, those developments in personal information and privacy seem incredibly significant now.
They are, without a doubt. While protecting business secrets is, a core job for breach of confidence, the most dynamic, the most rapidly evolving area recently has definitely been protecting personal information. And that's largely driven by the impact of the Human Rights Act 1998. Let's repeat that. While commercial secrets are key, recent focus is on personal information and privacy via the Human Rights Act.
Right, this brings us straight to that intersection then. How did this old judge-made action, based on conscience, become the main tool for protecting privacy in the UK? Especially with the Human Rights Act coming in. It feels like, I don't know, mixing old wine with new bottles, legally speaking.
That's a good way to put it. It's a fantastic example of how the common law adapts. Before the Human Rights Act 1998 became part of UK law, the courts consistently said again and again there was no freestanding right of privacy here.
No right to privacy at all.
Not as a distinct legal right, no. Judges sometimes expressed frustration. They felt their hands were tied even when there was a clear invasion of privacy. There was a case, K.V. Robertson, in 1991. An actor was badly injured, photographed and interviewed in his hospital bed without proper consent.
Oh, dear.
The Court of Appeal felt they couldn't grant an injunction based just on privacy, though he won on another ground. The key takeaway was the courts felt they couldn't just invent a general privacy right themselves. Remember this. Before the HRA in 1998, UK law did not recognize a general right to privacy.
Okay, so the HRA changed everything.
Completely changed the landscape. The HRA requires UK courts, when deciding cases, to take the European Convention on Human Rights, ECHR, into account, and specifically the case law from the Strasbourg Court.
Right, the European Court.
And the two crucial articles here are Article 8, the right to respect for private and family life, home, and correspondence, and Article 10, the right to freedom of expression.
And they often clash, I imagine.
Directly, especially when the media wants to publish personal stuff. So because the UK didn't have its own specific privacy law, the court started using the existing action for breach of confidence as the procedural vehicle, the legal framework, to actually give effect to those Article 8 privacy rights.
Okay. They repurposed it.
Sort of, yes. And in this specific context, where it's personal information and the complaint is really about an invasion of privacy, the courts increasingly call it misuse of private information rather than breach of confidence. Lord Nichols explicitly flagged this terminology shift in the absolutely crucial House of Lords case, Naomi Campbell v. Mirror Group Newspapers, Ltd. It shows that while it grew out of confidence, its privacy application has given it a distinct identity. Let's repeat that. Misuse of private information is the modern term for protecting privacy, using principles derived from breach of confidence, balancing Article 8 and 10 ECHR.
So it's kind of the same legal engine, but it's been specifically tuned up for privacy cases.
That's a great analogy. And its distinct nature was underlined even more by the Court of Appeal in Google Inc. v. Villahall. They held that misuse of private information is actually a tortious cause of action, a type of civil wrong, not purely equitable, which again sort of separates it slightly from traditional breach of confidence, which is purely rooted in equity.
Okay. Can we look at some cases? That always helps make it clear.
Definitely. The case law is everything here.
Right.
The Douglas v. Hello Ltd. saga, especially the interim Court of Appeal decision in 2001, was really a turning point. Now, the celebrity couple didn't get their injunction at that early stage. The court felt damages later would be enough compensation if they won, but the majority judges sent a strong signal. They said the extensive confidentiality arrangements the Douglases had made for their wedding photos, plus the impact of the Human Rights Act, could create a right of privacy that the law would protect. Lord Justice Sedley, in particular, made some powerful points about the HRA forcing the courts to develop the common law to protect privacy.
So a clear signal.
A very clear signal. Then you have Venables and Thompson v. News Group Newspapers, Ltd. This protected a different kind of privacy. The court granted permanent injunctions to shield the new identities and locations of two individuals convicted of murder years earlier after they'd served their time. The crucial factor was the very real, very serious risk to their physical safety if their new identities got out. It showed that safety is a really strong factor on the Article 8 side of the scales.
Right, life and limb.
Exactly. Then, the absolutely fundamental case, Naomi Campbell v. Mirror Group Newspapers Ltd. in the House of Lords. They found the Mirror had misused her private information by publishing details and, crucially, photos of her attending Narcotics Anonymous meetings.
The photos were key.
Very key. The court accepted the newspaper had some justification in revealing she was an addict because she'd publicly denied it. So setting the record straight was okay to some extent.
But they went too far.
They went too far, publishing the specific details of her therapy, where she went, and especially those photos taken outside the meeting place. The House of Lords viewed the photos as particularly intrusive, a serious violation of her privacy. Remember this one. Campbell v. MGN is a key case establishing misuse of private information protection for personal details and photos, balancing Article 8 and 10.
Okay, Campbell is vital. What about the European influence?
Hugely influential, especially from the Strasbourg court concerning public figures. In von Hanover v. Germany, 2004, the European court drew a distinction that UK courts have really picked up on.
What distinction?
They contrasted reporting on the official duties of politicians, where the press is a public watchdog and gets wide freedom under Article 10 with reporting on the purely private lives of people who don't hold official public roles.
Right.
In that second scenario, the court said, where photos and articles are just satisfying public curiosity, Article 10 freedom of expression is narrower, and Article 8 privacy rights usually carry more weight. Remember, von Hanover, 2004, distinguished between public figures' duties versus private lives and watchdog role versus satisfying curiosity.
So less protection for private lives, just for gossip.
Essentially, yes.
Yeah.
But then the European court refined this a bit in von Hanover v. Germany, 2012. This involved a photo of Princess Caroline skiing while her father, the ruler of Monaco, was seriously ill. It was taken in a public street in St. Moritz. The court accepted the German court's view that this photo did contribute, at least to some degree, to a debate of general interest. The illness of a reigning monarch is a contemporary event. Her status as a public figure, even not an official one, was relevant. They also noted the photo was taken in public, not secretly, wasn't offensive in itself.
So it's more nuanced.
It showed the balancing act is nuanced. Even for non-politicians, there might be some public interest in aspects of their lives, and the circumstances how the information was obtained matter. Remember, von Hanover, Note 2, confirmed balancing requires assessing the information value and contribution to a debate of general interest, even for public figures. Circumstances of obtaining information matter.
Okay, so drawing all that together, what's the actual test the courts use now for misuse of private information?
Right, pulling from those key cases like Campbell and von Hanover, and clarified in cases like Murray v. Express Newspapers and Re JR 38, the modern test is clearly a two-stage test.
Two stages, okay.
Stage 1. Did the claimant have a reasonable expectation of privacy regarding the information in question? This is judged objectively.
Objectively.
Meaning, you look at all the circumstances, the nature of the information, who the claimant is, are they a child, how the info was obtained, is it already widely known, and ask, would a reasonable person in the claimant's shoes expect this to remain private? That's the first hurdle. Remember, first stage of the test, reasonable expectation of privacy. The Murray case gives a useful checklist of factors.
Okay, reasonable expectation, what's stage 2?
If the answer to stage 1 is yes, then the court moves to stage 2, the balancing exercise. Here, the court weighs the claimant's right to privacy under Article 8 ECHR against the defendant's right to freedom of expression under Article 10 ECHR. It's about balancing the impact of disclosure on the claimant versus the public interest in the information being published. This is the crunch point, remember. Second stage. Balance Article 8 and Article 10 ECHR.
So for this privacy action, the information doesn't need to be totally secret, like you said, for traditional breach of confidence.
Exactly. That's a really key difference. For misuse of private information, it doesn't need to be top secret, known only to a handful. It could be known by quite a few people already. But if there's still a reasonable expectation of privacy against further publication or publication to the world at large, the action can still succeed.
Can you give an example?
The Supreme Court case, PJS v. News Group Newspapers, is perfect. Details about the claimant's private life were already all over the internet internationally.
Right.
But the Supreme Court still granted an injunction preventing newspapers in England and Wales from publishing it because that specific type of publication would cause significant additional distress and harassment. So there was still a reasonable expectation of privacy against that form of dissemination, remember. For misuse of personal information, relative secrecy applies. Information known by many can still be protected if there is a reasonable expectation of privacy.
That's subtle.
It is, and this area keeps developing. Recent cases like Rockroll v. Newsgroup newspapers confirmed info known to others can still be private. Bull v. Desport involved really sensitive details about a private sex life, strong expectation of privacy, very little public interest. The court also noted whether the info was true or false didn't matter for whether it was private.
Ah.
ZXC v. Bloomberg looked at privacy during a criminal investigation before any charges. That required a delicate balance between the individual's privacy in their financial dealings and the public interest in how state bodies share information.
Okay. What about the Duchess of Sussex case? That got a lot of attention.
It did, and it's a great illustration of the test in action. HRH Duchess of Sussex v. Associated Newspapers, Ltd., about publishing extracts from that letter to her father. Warby J. at first instance applied the two-stage test very clearly. Stage 1. Reasonable expectation of privacy. Yes, definitely. He looked at the Murray factors. The letter's contents were inherently private and personal. Disclosure would likely cause distress. It wasn't already fully public. Even though she'd let friends brief a biographer about some things, that didn't wipe out her privacy expectation for this specific letter.
Okay, so she passed stage 1. What about the balancing?
Stage 2. Balancing Article 8 and 10. The judge found that publishing such a huge chunk of the letter was a disproportionate interference with her Article 8 privacy rights. And the newspaper argued they needed to publish it to correct a misleading impression given elsewhere.
Right.
But the judge said the sheer amount published went way beyond what was necessary for that purpose. It was overkill.
Yeah.
And the Court of Appeal agreed. Remember, HRH Duchess of Sussex case applied the two-stage test, highlighting disproportionate interference from extensive publication, even if there was an argument for some public interest.
That case really shows how they dissect the details, doesn't it? The amount published versus the justification. It also makes me wonder about relationships, like, does employing someone automatically create this expectation of privacy?
It certainly helps establish it. Cases like McKennett v. Ash, the defendant, was the claimant's former PA, or HRH, Prince of Wales v. Associated Newspapers, Ltd., involving staff who took a private diary, show how that employment relationship strongly points towards an expectation that things shared within it stay private.
Makes sense.
Though, interestingly, going back to Douglas v. Hello, Ltd. In the House of Lords, they actually saw the claim by OK Magazine against Hello as primarily a commercial breach of confidence. Why? Because OK had that exclusive contract for the photos. The confidentiality was for their commercial benefit as much as the couple's privacy. So sometimes the same facts can trigger both traditional confidence and misuse of private info, depending on who's suing and why.
What about this idea of public figures courting publicity? Does that mean they lose their privacy rights?
That's been a tricky area. Some earlier cases, like AVB, a company involving a footballer, or Theakston v. MGN with a TV presenter, did seem to suggest that if you seek the limelight, you significantly weaken your claim to privacy.
So you live by the sword, die by the sword.
Kind of the feeling then. But post Von Hanover, the courts have definitely refined that. Cases like McKennett, HRH Prince of Wales, and the Max Mosley case have really emphasized the distinction between public duties and purely private life, especially for people who aren't politicians.
Right.
Now, the press is generally allowed to publish private information to correct the record if a public figure has made false or misleading public statements about their private life. We saw that in cases like Woodward v. Hutchins, Campbell itself, and Brown v. Associated Newspapers.
Okay, correcting the record is allowed.
Yes. But just being famous doesn't give the press a free pass to expose every detail of their private life just to show they have feet of clay, as the Court of Appeal memorably put it in the Campbell case. Remember, seeking publicity doesn't remove all privacy rights. The distinction between in the public interest and of public interest is crucial for the defense.
That distinction, again, in versus of public interest, seems absolutely vital, especially when we get to defenses later. It's a really complex, evolving area.
It really is. And it just shows how this judge-made law is constantly adapting, trying to fit old principles to modern media, technology, and crucially, integrate human rights effectively.
Fascinating.
Oh.
Okay, let's switch back to the traditional side for a moment. What are the absolute nuts and bolts, the specific legal conditions a claimant must prove to win a traditional breach of confidence claim?
Right, back to basics. And the source material is spot on here. The absolute cornerstone case is Coco v. Clark, 1969. Mr. Justice McGarry reviewed all the earlier law and boiled it down to three essential conditions. These are the absolute building blocks.
Okay, three conditions.
Three conditions from Coco v. Clark, absolutely crucial. One, the information itself must have the necessary quality of confidence. Two, it must have been imparted in circumstances importing an obligation of confidence. And three, there must be unauthorized use or threat of use of that information. Let's break those down.
Okay, number one, necessary quality of confidence.
Right. As we said, it's broad, can be spoken, written, plans, ideas. But it has limits. Lord Gough, in the Spycatcher case, said it can't be trivial, useless, or totally vague. It also can't be immoral, but that means information about crimes or fraud, not just something distasteful. The Mosley privacy case confirmed that. It also needs to be identifiable, reasonably certain. Really vague, half-formed ideas usually don't cut it. Contrast to Maudsley v. Palumbo, early ideas for a nightclub, too vague, with Fraser v. Thames Television, where the TV show idea was specific enough. Bailey and Williams v. Graham, the Levi Roots reggae sauce case, also showed the claimed secret process had to be clear enough, and part of it wasn't.
Okay, not vague. What's the most critical part?
The absolute key point for traditional breach of confidence. It must not be in the public domain. It has to be, essentially, secret. Lord Gough in Spycatcher put it simply. It must not be something which is public property and public knowledge. Remember, information must be secret and not in the public domain. If it's freely available, published book, public website, government registers, and a little bit, it generally loses its confidential quality. BBC v. HarperCollins about the Stiggs identity is an example. Once it's widely known in the relevant circles, it's probably not confidential anymore.
So does any publication kill it? Like if it's mentioned once in an obscure journal?
Not necessarily anywhere. Secrecy here is understood as relative, not absolute. The Supreme Court confirmed this in Vestergaard Franson v. BestNet Europe. Sharing info with a small group who are also bound by confidence doesn't automatically destroy it for everyone else.
Oh, okay.
Like a company shares projections with its board and auditors still confidential to the outside world. Or, back to the Stig, telling a few media people who promise not to reveal it doesn't make it public knowledge overnight. Remember, secrecy is relative, not absolute.
Right. What about this springboard idea?
Ah, yes, the springboard doctrine. This is important. Even if some bits of the information are public, if the defendant uses the confidential information they received as a package to get a significant head start or commercial advantage they couldn't have got otherwise, the court can still step in.
A head start.
Yeah, the idea is they shouldn't be allowed to use the shortcut provided by the confidential disclosure to springboard ahead of competitors who'd have to do the hard work of gathering the public bits or developing it themselves. Say you get secret manufacturing plans, even if you could maybe reverse engineer the product eventually, using the plans gives you an unfair jump, and the springboard doctrine can stop that or make you pay for it.
Okay, got it. So that's condition one, confidential info. What about number two? Obligation of confidence.
Condition 2, obligation of confidence. This is all about how the recipient got the information and whether the situation imposed a duty on them not to misuse it.
How can that duty arise?
Several ways. It can definitely come from a contract and express confidentiality clause, or sometimes an implied term. It can arise from recognized relationships of trust employer-employee, lawyer-client, doctor-patient, business partners, joint ventures. Those relationships inherently involve confidentiality.
Right.
But, and this is really crucial for the breadth of the action, the obligation can also arise simply from the circumstances of the disclosure, even with no prior relationship or contract. And this is judged objectively.
Objectively how?
Using the reasonable person test from Coco v. Clark, Macquarie J. said. If the circumstances are such that any reasonable man standing in the shoes of the recipient would have realized that upon reasonable grounds the information was being given to him in confidence, then this should suffice. Basically, would a reasonable person in their position have known it was confidential? That's the key test. Remember, the objective test for the obligation is whether a reasonable person would know the information was confidential. It was approved in Spycatcher and Naomi Campbell.
So even if someone just overhears something or finds a document, if it looks confidential, they might be caught.
Potentially, yes. A good example is Stevens v. Avery. A woman told a friend about her private lesbian relationship. No contract, just friends talking. The court said any reasonable person getting such intimate personal details from a friend would understand it was confidential, not something to sell to the tabloids. The circumstances created the obligation.
Okay. What about employees? That must come up a lot.
It does. Let's look specifically at employees and ex-employees.
Right.
While employed, employees owe their employer a basic duty of fidelity or loyalty. That's established in cases like HIVAC, LTDV Park, Royal Scientific Instruments, and this duty includes keeping the employer's confidential information secret. It's an implied part of the job, as seen in Printers and Finishers, LTDV Holloway. Senior staff, directors might even be fiduciaries with higher duties.
Okay, that's while they're employed. What about after they leave?
Different ballgame for ex-employees. Once they leave, they're generally free to use their own skills and general knowledge gained on the job, but they're still bound by confidence for certain types of information. The absolutely key case here is Facenda v. Fowler.
Facenda v. Fowler.
Yes. It categorized information for ex-employees into three types. First, genuine trade secrets, like the secret formula for Coke, a really unique process. That stuff is protected both during and after employment, automatically.
Okay.
Second, less secret but still commercially sensitive information. Think customer lists, pricing details, marketing plans. This is protected during employment by the duty of fidelity. But to protect it after the employee leaves, you generally need an express confidentiality clause in their contract.
Right, needs a specific clause.
Usually, yes. And third, general skill and knowledge. This is the employee's own expertise, experience, know-how they've built up. That's not confidential, and they can take it and use it freely wherever they go next. Remember this breakdown. For ex-employees, information is categorized. Trade secrets, protected during and after. Commercially sensitive info, needs express clause after employment. General skill knowledge, not protected.
It sounds like distinguishing between type 1 and type 2 could be tricky sometimes.
Very tricky. That's often where the legal fights happen. And that Shenzhen v. Selgard case we mentioned earlier, it confirmed the COCO elements, the need to specify the information, but it also explicitly reaffirmed Facenda v. Fowler, and another case, Lancashire Fire's Ltd v. SA Lyons, as correctly stating the law for ex-employees.
Okay. What about third parties, people who weren't the original recipient?
Yes, third-party recipients. This is a really significant area where the law has broadened quite a lot.
So if I tell you a secret and you tell someone else, are they automatically liable if they use it?
Not automatically, but it's much easier to catch them now than it used to be. Originally, the thinking was maybe a third party was only bound if they knew the information was passed to them in breach of confidence by the original person. But the law now puts more weight on the nature of the information itself and what the third party knew or should have known. Remember, third parties are bound if they receive information knowing or ought to know it is confidential.
Ought to know.
Yes. Lord Keith in Spycatcher said, a third party who gets confidential info and knows it's confidential might have a duty not to pass it on. Lord Goff, in the same case, gave those great examples. What if a confidential document blows out the window? Or a private diary is dropped and found?
Right, you mentioned those.
Lord Goff suggested that even with no prior relationship, no initial breach, the nature of the information itself might be so obviously confidential that the finder is instantly under an obligation not to misuse it.
So it can catch people who find things, or even, say, hackers or spies.
Exactly. It means people who get information illicitly, eavesdroppers, industrial spies, maybe even hackers without any connection to the owner, can still be bound simply because the information they've got is clearly confidential on its face. Justice laws confirmed this in Hallowell v. Chief Constable of Derbyshire with his example of taking a private photo with a long lens. Publishing that would be a breach. And the House of Lords agreed in Douglas v. Hello in 2008. Remember, the obligation can arise simply from receiving information you know is confidential, even if you acquired it illicitly.
Wow.
And even more, in Chinglis v. Eimerman, the court said deliberately taking steps to acquire confidential information without permission can itself be the breach. Not just using it afterwards, but the act of getting it improperly.
Okay. How do they judge if a third party ought to know?
It's an objective assessment of notice, confirmed in Primary Group, UK, Ltd v. RBS. What would a reasonable person in their position, given all the circumstances, have realized about the information's confidentiality?
But there must be limits. Can't be expected to investigate everything.
No, there are limits. The Racing Partnership Limited v. Sports Information Services Ltd showed this. A defendant got information from a reputable third party who actually promised it wasn't confidential. The Court of Appeal said the defendant wasn't bound.
Why not?
Because in that commercial context, relying on a warranty from a reputable source, they weren't reasonably expected to dig deeper. They weren't put on notice. So context and commercial realities matter.
Okay. And who can actually sue? Standing?
Good question. Only the person or company to whom the obligation of confidence was owed has standing to sue, but it can be owed to more than one party. Remember the Douglas v. Hello case in the House of Lords?
With the wedding photos.
Yes, they decided the obligation was owed both to the celebrity couple and to OK Magazine because everyone knew the secrecy was partly for OK's exclusive deal. Remember, standing is limited to the person owed the obligation. It can be owed to multiple parties.
Okay, that covers the obligation. What's the third condition from Coco v. Clark?
Condition 3, unauthorized use or disclosure. This one's usually more straightforward. Did the defendant use the information for a purpose different from why it was given? Or did they pass it on to someone else without permission?
Simple enough.
Uh-huh.
Does the claimant have to show they suffered some harm, some detriment?
Detriment. That's a slightly tricky point. Is it absolutely required to prove liability? The House of Lords in Spycatcher actually left that question open. For commercial secrets, detriment is usually obvious: lost sales, lost advantage. For personal information, maybe the mere invasion of privacy by disclosure is enough detriment in itself. McKenna v. Ash suggested that, though some earlier cases, like Douglas at first instance, seem to want something more tangible for celebrities.
So what's the current thinking?
The better view, probably, and the one courts often lean towards, is that while detriment is nearly always there and definitely affects the remedy, how much compensation you get, it's not strictly a separate ingredient. You must prove just to show a breach happened. The unauthorized use is a breach. The harm suffered then dictates the damages. And just one quick related point from Warren v. DSG Retail Ltd. Breach of confidence imposes a negative duty: don't disclose, don't misuse. It doesn't usually impose a positive duty to actively take steps to prevent accidental loss. Remember, the third condition is unauthorized use or disclosure. Whether detriment is strictly required for liability is debated, but it affects remedies.
Okay, that's a lot to take in, especially all the nuances around employees and third parties.
Yeah.
But having those three core conditions from Coco v. Clark: confidential info, obligation, unauthorized use as the framework is really, really helpful for structuring it. Especially for exams, knowing those 3 points in the key cases is vital.
Absolutely. No Coco v. Clark inside out, the 3 conditions, what they mean, and you've got the backbone for traditional breach of confidence. And always remember the different test for misuse of private information.
Right, so if a claimant ticks all those boxes, they've made their case. But what can the defendant argue back? What are the defenses?
Good point. Apart from the obvious arguing the claimant actually consented, or that the information was already public knowledge anyway, which means it fails condition 1 of COCO, the main substantive defense is disclosure in the public interest. Remember, the primary defense is disclosure in the public interest.
Public interest, okay.
Now, pleading this isn't saying the information wasn't confidential. It's saying, yes, it was confidential, and yes, I breached that confidence, but I was justified in doing so because it served a greater public good. It's a justification defense. You see it in copyright law, too.
Right.
Especially since the Human Rights Act. This defense often gets framed within that balancing exercise we talked about for privacy cases. Balancing the claimant's rights, Article 8, privacy, or maybe Article 1, Protocol 1, property rights for commercial secrets, against the defendant's Article 10, right to freedom of expression, which includes the public's right to receive information. And here's that absolutely crucial distinction again. The disclosure must be in the public interest, not just of public interest. This is fundamental.
Is that again?
It needs to be in the public interest, not merely of public interest. Loads of things might be of interest to the public: celebrity gossip, private scandals, but that doesn't mean it's in the public interest to publish them in breach of confidence or privacy. The defense is about things like exposing crime, fraud, serious misconduct, dangers to public health or safety, miscarriages of justice, or contributing to a genuinely important public debate. Remember, in the public interest is the defense, not merely of public interests.
So it's about exposing wrongdoing or real public benefit.
Exactly. It has roots in old sayings like, no confidence in the disclosure of an iniquity, meaning you can't use confidentiality to cover up crime or fraud. Cases like Gartside v. Outram established that early on. In Initial Services Ltd v. Putterill, an employee was justified in revealing his employer's anti-competitive practices because that was seen as an iniquity. But even if you're exposing wrongdoing, you generally shouldn't disclose more than necessary or to more people than necessary. Telling the police might be justified, but splashing it all over the front page might not be, especially if it harms others unnecessarily. That came up in Francom v. Mirror Group newspapers.
Okay. Are there clear examples where the defense worked?
Yes. Lion Laboratories v. Evans is a great one. Internal documents showed a police breathalyzer device was unreliable. Publishing that was held to be in the public interest because of the risk of wrongful drink driving convictions.
Makes sense.
In Hallowell v. Chief Constable of Derbyshire, the police putting up wanted posters with the suspect's photo was considered justified in the public interest of catching criminals.
Okay. What about more recently in a commercial setting?
The Brevin Howard Asset Management LLP v. Reuters Ltd case is helpful. A hedge fund tried to stop Reuters publishing confidential info about its performance. The Court of Appeal upheld the injunction. They stressed again, the test is whether breaching the duty of confidence is in the public interest, not just whether the info itself is of interest. They weighed the public interest in financial market transparency against the fund's right to confidentiality over its sensitive commercial data and found the balance favored confidentiality in that case. There wasn't a strong enough public interest justification to breach the duty. Remember, in Brevin Howard, the CA confirmed the test is whether breaching the duty is in the public interest, emphasizing balancing rights and the context, like financial confidentiality.
Okay. And you mentioned government information earlier. Is it different for them?
Yes, when the government tries to stop publication of its own information, like in Spycatcher or the AGV Jonathan Cape Ltd case about the Crossman Diaries, the government has an extra hurdle. It's not enough to show the info is confidential. They also have to prove it's in the public interest that it should not be published.
So the presumption is slightly towards publication for government info.
Exactly, unless they can show a compelling reason for secrecy, like genuine national security risks.
So that public interest defense, it sounds powerful, but quite specific. It's not just a get-out-of-jail-free card for publishing anything juicy. It needs real justification and careful balancing.
Precisely. It's a high bar, focused on genuine societal benefit outweighing the confidence or privacy right.
Okay, so let's say the claimant wins. They prove the breach. The defendant fails on defenses. What can the court actually do? What remedies can the claimant get?
Right, the remedies. Once a breach is established, the court has a toolkit of options. The most common are injunctions, court orders to stop misuse, and various forms of compensation, usually damages or something called an account of profits. Proprietary remedies, like declaring a trust over the information, are generally off the table in the UK now. Remember, remedies include injunctions, compensation, damaged account of profits, and less often proprietary relief.
Okay, let's start with injunctions. Stopping them using it.
Exactly. An injunction is often the first thing a claimant wants, especially if the information isn't widely out yet. It's a court order telling the defendant, stop using this, stop disclosing it.
Can you get one even if the information is already leaked out a bit?
That's been debated. Some older cases, like Speed Seal v. Paddington, suggested maybe you could still get an injunction even if it was somewhat public. But the more modern view, and the one generally preferred, now strongly supported by Arnold J's review in Vestergaard Franson v. Bestnet Europe, is that once the information is truly in the public domain, readily available, the court generally won't grant an injunction.
Why not?
Because the cat's already out of the bag. An injunction can't make secret again what is already public knowledge. At that point, the main remedy shifts to compensation for the harm already done. Remember, injunctions generally won't be granted once the confidential information is in the public domain.
Okay, so if an injunction isn't possible or isn't enough, we move to compensation.
Exactly. Compensation. This aims to either pay the claimant for the loss they suffered or to make the defendant give up any profits they made from the breach. Calculating this has been, well, a bit messy sometimes with different approaches.
How does it work if there was a contract?
If the breach of confidence also counts as a breach of contract because there was a confidentiality agreement, then you can claim normal contract damages. The aim is to put the claimant in the financial position they'd have been in if the contract hadn't been broken.
Can they get the defendant's profits?
Usually not just for a simple contract breach, but in exceptional cases, an account of profits might be available. The big case here is A.G. v. Blake.
The spy case.
Yes, the former MI6 agent who published his memoirs breaching his lifelong duty of confidence to the Crown. The House of Lords awarded an account of his profits, saying his duty was so fundamental, almost like a fiduciary's, that stripping his profits was justified in those unique circumstances. Remember, if a contract is breached, normal damages or account of profits, in exceptional cases like A.G. v. Blake, are available.
Okay, that's exceptional. What if there's no contract?
That's where it gets murkier. What's the legal basis for damages then? Is it under the Senior Courts Act, Section 50, which allows damages instead of or as well as an equitable remedy like an injunction? Or is there some independent common law right to damages for breach of confidence? The courts haven't always been totally clear.
And how do they calculate the amount?
Again, different methods have been used. In Seeger v. Copydex, No. 2, the Court of Appeal calculated damages almost like it was the tort of conversion, valuing the confidential information like stolen property based on the market value of the infringing product.
Right.
A different approach, seen in Dowson and Mason v. Potter, is to award a reasonable license fee. Basically, what would the claimant have reasonably charged the defendant for permission to use the information? This is quite common in other IP cases like copyright. Remember, without a contract, damages calculation can be based on conversion, Seeger, or a reasonable license fee, Dowson and Mason.
What about for privacy cases, misuse of private information?
There, damages are usually focused on compensating for the emotional distress, the hurt feelings, the loss of dignity caused by the privacy invasion. Cases like Bull v. Disport, where £12,500 was awarded, follow principles from cases like Galati v. Mirror Group newspaper on how to assess damages for privacy breaches, sometimes including extra aggravated damages if the defendant's conduct was particularly bad.
And going back to Douglas v. Lowe, again, what did they get?
Well, the final damages award really highlighted the difference.
Okay.
The magazine, with the exclusive contract, got substantial damages for their huge commercial losses. The celebrity couple, the Douglases, only got a relatively small sum for their distress. It really shows how the actual detriment suffered drives the amount of compensation, even if its role in proving liability is debated.
Okay. What about this proprietary relief you mentioned? Constructive trusts.
Right, proprietary relief. The idea was, could the court say the defendant holds any gains made from the breach on constructive trust for the claimant, implying the claimant somehow owned the information or its proceeds? This was toyed with, notably in Canada, in LAC Minerals v. International Corona.
But not in the UK.
Generally rejected here, yes. And Canada also moved away from it later in Cadbury Schweppes v. FBI Foods. The House of Lords in AG v. Blake basically confirmed the UK position. There's generally no property right in the information itself that justifies imposing a constructive trust. Remember, proprietary relief, constructive trust, is generally not available. Account of profits is the preferred remedy for illicit gains.
So instead of a trust.
Instead, AGV Blake said an account of profits is the better equitable remedy to strip away the defendant's gains, especially, they suggested, where the defendant was in a fiduciary or quasi-fiduciary position like crown servants, maybe senior employees in positions of great trust.
Okay, so remedies cover stopping the breach, compensating for loss, or taking away profits, but the calculations can vary, and you can't usually claim ownership of the info itself.
That's a really good summary of it. It's an area where courts have flexibility and have used different tools depending on the facts. So just to bring it all together, a quick recap. The action for breach of confidence, based on equity, good faith, conscience. For traditional claims, you need the three Coco v. Clark conditions: confidential info, obligation circumstances, unauthorized use. Remember, recap. Breach of confidence is based on good faith, requiring Coco v. Clark's three conditions.
Right.
For personal information and privacy, it's evolved into misuse of private information. Different test. Reasonable expectation of privacy, then the crucial balancing of Article 8 and Article 10 ECHR, guided by cases like Campbell and von Hanover. Remember. Recap. Misuse of private information uses the reasonable expectation test and balances Article 8 and 10 ECHR. The main defense. Disclosure in the public interest, high bar. Must be in the public interest, not just of public interest. Involves balancing rights. Remember, recap. The main defense is disclosure in the public interest, requiring a balancing of rights.
Okay.
And remedies. Injunctions, but usually not if info's public. Compensation, damages, maybe account of profits. Calculation can be complex without a contract. Constructive trusts generally unavailable. Account of profits preferred for stripping gains, especially from fiduciaries. Remember, recap. Remedies are injunctions, if info not public, and compensation, damage to account of profits. Constructive trusts are generally not granted.
That's a fantastic summary of the key pillars. Now, given it's judge-made law, always adapting, are there still bits that are a bit fuzzy or where different cases seem to pull in slightly different directions?
Oh, absolutely. As with any area of common law development, there are always rough edges or areas needing more clarity. The source material flags a few. For instance, well, the precise method for calculating damages when there isn't a contract, the Seeger conversion approach versus the Dowson and Mason license fee approach, when is each one right? Still not perfectly settled? The exact legal role of detriment, is it essential for liability itself or just about how much money you get? Still debated.
Okay.
Drawing that line for ex-employees between protected, commercially sensitive information and their own general skill and knowledge that can be incredibly difficult on the specific facts, leading to seemingly different outcomes.
I can imagine.
And applying the public interest defense and the Article 810 balancing act in completely new situations, especially with new technologies generating or sharing information in novel ways, that's an ongoing challenge for judges, requiring careful judgment calls.
Yeah.
So those are areas where future cases will likely continue to shape and refine the law.
It makes total sense, doesn't it? That a dynamic, judge-made area like this is constantly being tested and tweaked, especially with technology changing everything, and human rights having such a big impact on privacy law. Well, that was a truly comprehensive deep dive into breach of confidence. We've gone from its roots in fairness and equity right through to its modern role in protecting privacy. We cover the essential conditions from Coco v. Clark.
We explored that crucial evolution into misuse of private information. The vital Human Rights Act, balancing act between privacy and expression, looked hard at the public interest defense and examined the remedies. Understanding these core principles, the different tests, and those key cases like Campbell v. MGN, Von Hanover, and Coco v. Clark is absolutely fundamental.
It really is, and it just hammers home how careful everyone needs to be with confidential information, whether you're in business or just dealing with personal stuff. And we must remember, this material was made available for educational purposes by the University of London.
And this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
And again, seriously, for all of you out there hitting the books for exams, the very best of luck. Keep reviewing those cases, think through the principles, apply them to new facts. You've done the work. Trust yourselves.
Here, here. Good luck, everyone.
And maybe as you continue thinking about this, here's a final thought. In a world where information travels instantly, globally, and where AI can analyze data in ways we couldn't imagine even a few years ago, how well can these judge-made principles of confidence and privacy, born in a very different era, actually keep up? What fundamentally new legal ideas, or maybe even technological solutions might we need to protect ourselves and our information effectively in the future?
That's a huge question, isn't it? Really highlights the ongoing challenge for the law to stay relevant in the face of relentless change.
Something to ponder. Thanks for joining us for this deep dive.